Hey, Steve. Glad you could join us. This is Andy with the Capacity Building Center for Courts, and we have with us a number of folks from the court improvement programs across the country. As we talked about, this is the Indian Child Welfare Act Community of Practice, and today what we'd like to do is basically pick your brain a bit about the relationship between the new federal regulations, the guidelines, and the way that they interact with state and federal law, both case law and state statutes. So in a second here, I'm going to open it up and let people ask some questions. But before I do, I want to just make sure that you're all plugged in from a tech side. Obviously, we have you on the phone. Are you in front of a computer where you can log into the Adobe Connect room?
Probably. Well, I'm actually in a parking lot right now. I'm going to see here if I can link, create a hotspot here, and if so, I'll be able to do that. So,
okay. If you can't, it's not the end of the world. If people ask questions over the chat box, I can read them out loud to you. But let's just go ahead and jump in and kind of get started here. So, the issue that came up last month with our constituency group was it really came, the specific instance that gave rise to these sets of questions is the state of Utah developed a quick reference card or a quick reference guide for use by attorneys and judges and other court stakeholders to promote a common or uniform understanding of the new regulations, guidelines, and the federal statute. And it's excellent for what it's worth. Gabriella Archuleta led a group of folks in Utah that put it together, and it's since been adapted by a number of other states like Louisiana. But there also was a little bit of pushback from Utah agency attorneys, if I recall, around the legal force of the regulations and whether or not the quick reference guide was accurate in its portrayal of the regulations and their legal force in relationship to state law. So it was a little bit wordy, but that's basically the specific issue that came up. Now, this group works across the country. We sort of troubleshoot each other's problems as they come up and kind of, through the collective wisdom of the group, resolve issues or promote ICWA compliance or work on projects together across jurisdictions. So that's a little bit of the context. I know you and I have spoken about this before, but just so that we're all on the same page. So maybe we can start with a broad question, and then as people have questions, I'll invite you to type them into the chat box, and I'll read them aloud to Steve. And don't be shy, or you can raise your hands using the icon on the top of your screen. There's a little person with a hand raised. If you hit that, I'll see that you've raised your hand. I can call on you, and then you can ask your question over the phone as well by yourself. So 2 ways to ask questions. Type them into the chat, and I'll read them, or you can just raise your hand or interrupt me and speak over the phone. And we'll see what kind of insight Steve has to offer. So, I'll just throw out the first question, Steve, and you can pick it up from there. And then I'm sure the questions will go in. So the first question is this: what is the legal force of the regulation if they conflict with state law?
Well, federal primacy would tell us that the regulations are going to be are going to control state law. Now, the exception to that would be under 25 U.S.C. 1951, which says that state courts or state laws would control in ICWA cases if and only if they go beyond the Indian Child Welfare Act or in this case the federal regulations. So if, for instance, just to give an example, in Oklahoma, we require notice to be given for all proceedings and hearings, not just for proceedings. And that notice has to be given by certified mail, not registered mail. That's a case where the law clearly goes beyond that anticipated in the minimal requirements of ICWA and the federal regs. Now, a state could not, for instance, decide that notice was going to be given by email. That would be a lesser notice requirement, and that would violate the regs. Otherwise, you've got basic Chevron deference, where state laws are going to be subject under the regulations. Does that answer the question?
It does. I'm just typing the pause there you're hearing as I'm typing into the chat box just some of the highlights that you're saying and throwing them in there so that people have something to chew on. Now, Gabrielle, I don't want to put you on the spot, but I'm going to put you on the spot. I hope that's okay. You mentioned that there was potentially even a legal memo being drafted by the agency in Utah. Gabrielle is the court improvement coordinator for the state of Utah. And she's the one that sort of initially raised this issue, but not the only one. There were echoes of it within the community. And I believe they've raised the issue around Chevron as well. Gabrielle, is that right?
Yeah, that's the very issue that it's our Office of Guardian Ad Litem that have an issue with that. Our Utah Supreme Court has said that they don't grant Chevron deference to agency opinions. And at this point, the case law that was offered was only referring to Utah case law. But I did find another case that dealt with some federal regulations, and so that's where the contention is coming up, where the Guardians and I think other people are concerned that we shouldn't even follow these regulations because when it comes down to it, our Supreme Court isn't even going to grant it a higher level of deference and won't treat it with the force of law that the BIA is saying it should be treated with.
Well, I would say that that's obviously going to end up in federal court where they will certainly treat the regulations with a higher level of deference. Chevron is pretty much established case law, and you've got City of Arlington as well. Those decisions very much would demonstrate that federal regulations, if properly issued, and there's not much question that these regs were properly issued, they're going to be the law. Now, there is still a question of the Congressional Review Act and whether or not Congress is going to do something to it, but there hasn't been any indication that they're interested in this or that they're going to raise these issues. So, there are going to be states who no doubt are going to argue that they are not required to follow the regulations. I do not believe that they're going to be successful with that particular movement. That's just, federal regulations are federal regulations, and I think that issue was pretty well settled in 1865. So that's me being a little snarky, but the regs are the regs, and there are certainly things within there that probably will need to be considered by the courts, but I don't really see any way where you can just proactively decide that the regulations are not going to be followed.
Great, thanks. I'm going to write that sentence, the 1865 sentence, in my brief when this does go to federal court.
Well,
Yeah, that's great. Okay, so we have another question here from Ann Gilmore. So, Ann, I don't want to put words in your mouth. You've written in the chat box a really nice question, but maybe you can ask it over the phone to Steve.
Sure. So, I don't have the precise regulations in front of me, but the regulations talk about initiating a foster care proceeding. You have emergency proceedings, and then you have foster care proceedings, and then you have termination of parental rights proceedings. And so when I initially read the regulations, and this is still my opinion, is that if a child is removed from parental care, and you have reason to know that's an Indian child, and they are placed, involuntarily placed with a non-parent, that has to either come, it has to come within the definition of one of these ICWA proceedings. So it has to either be an emergency proceeding or you have to comply with the requirements for a foster care placement, which include qualified expert witness and a showing of active efforts. And if you're not doing that, then you have to meet the emergency removal requirements. So you have to, meet all of those evidentiary requirements that are set out. And county council here in California have been taking a different view, where the way it works in California is you can have a removal, and then as the petition is filed within a certain number of court days, and you have an initial hearing. And the difference of opinion is about what has to take place at that initial hearing. It's my opinion that you either have to meet the emergency proceeding requirements, or you have to have qualified expert witness and showing of active efforts. Whereas county council is saying, no, it's not really an emergency proceeding because we have filed a petition to commence foster care proceedings. And there's nothing in the regulations that says we have to have a qualified expert witness and showing of active efforts at that very first hearing. And there's even dispute about whether they have to get to that within 30 days. Often in California, we don't get to the disposition hearing where they've normally been doing their ICWA compliance for 60 days. And so that just seems wrong to me. I feel that when you have reason to know it's an Indian child and they are involuntarily removed from their parents, you have to have ICWA compliance in some way. So that initial hearing should be treated as an emergency proceeding, and that the removal should not last for longer than 30 days without getting to the full suite of ICWA compliance, including qualified expert witness. But I'm meeting a lot of resistance with that interpretation.
Well, if I may ask, California has the California Indian Child Welfare Act.
Yes, we do.
Does it have, what does it say about emergency hearings? Is it similar to Oklahoma's Indian Child Welfare Act?
It doesn't really say very much specifically about, so I'm not familiar with the Oklahoma emergency or Indian Child Welfare Act stuff, but we don't have a specific statutory scheme dealing with ICWA emergency proceedings.
Okay. So there's no language here that would particularly apply other than 23.113.
Mm-mm.
Okay. Well, I think that it's always going to be. Is there anyone from Texas on this line? On this call? No one from Texas?
Not seeing anybody, Steve. Yeah.
Okay, well, good, because I can talk smack about them then. Okay, Texas has a case called Mijas, which is kind of a similar. It sounds like kind of a similar situation there, and they may actually this might be the impact there. In that Texas case, they've got a very narrow definition of what a conservatorship is. And even though a conservatorship walks like a duck, quacks like a duck, and certainly looks like a duck, they're arguing that it would not be a child custody proceeding under 25 U.S.C. 1903. And so for that reason, and I think for kind of the variety of the way that they use it, a conservatorship comes about under not so much under a district court proceeding, but under their justice of the peace proceedings. Basically, because of that, they've said that ICWA doesn't apply, and it kind of sounds like they're arguing that a foster care proceeding is the same sort of animal, maybe, where they're saying you don't have to follow the emergency proceedings, but instead you just have a foster care placement, and that's different somehow?
Well, I think it's that there's language in the regulations, and it might, I should have looked at it more closely, but it talks about initiating a foster care proceeding. So, the emergency proceeding cannot last longer than 30 days normally, and that the emergency proceeding is ended by initiating the foster care proceeding. And so, as I understand County Council's argument is that they do initiate the foster care proceeding by filing the petition that will ultimately lead to a foster care placement, and their position is that although the child is removed prior to even the initial hearing, there's not actually a foster care placement within the meaning of that term until we get to disposition. And we've initiated the foster care proceeding, and there's nothing to say that we have to get to disposition within a certain time. As best I understand their argument, that's what they're saying is, in California, we have traditionally treated the disposition hearing when the court actually orders the child into foster care placement as the time at which we need the showing of active efforts, and we need the qualified expert witness testimony. And what they're saying is the foster care proceeding is initiated by the filing of the petition, and the actual foster care placement is not made until we get to disposition. And their view is that there's nothing that says we have to get to disposition within X number of days. But the way I read the regulations and the explanatory language, when the regulations were published in final form, and then the guidelines, I think that, they make it clear that whatever the state structure for child welfare, the goal is that when you know that it's an Indian child, or you have reason to know, they have to fall within one of these definitions of Indian child custody proceedings, and you're not to have a removal generally lasting more than 30 days without the full suite of ICWA protections. And you can't get around that just by filing the petition.
Well, yes, I guess I'm having trouble understanding what their argument precisely is, because it sounds like that they're saying that they're filing a petition so they don't have to follow ICWA?
Well, no, what they're saying is they're filing a petition that is initiating the foster care proceeding. And that's really all that the regulations say has to be done within 30 days. You just have to initiate the foster care proceeding. It doesn't say you have to have the qualified expert witness testify and a showing of active efforts within that time period. And the thing in California that they all point to is that, often in California we will not get certainty as to whether or not the child is an Indian child within 30 days. It's the rare case that you will actually get the information you need to make that determination, yes or no, within 30 days. So their argument is that, it's just impractical to think that we're going to get to a hearing and have qualified expert witness testimony when you will not have even identified the child's tribe, and you won't know for certain whether they're an Indian child.
Right. That's kind of, I'm kind of curious as to how then they would approach 23-120, where, the state court, it says prior to ordering an involuntary foster care placement, the court must conclude active efforts have been made to prevent the breakup of the Indian family, and that you've got to document those in detail. I kind of understand what they're saying. There's a similar case from about, 20 years ago, out of, I believe, Wyoming, where the court said, well, we can't really have 1912 protections before we have hearings. Even though if you read 1912D, it pretty clearly indicates that you should have those hearings.
Right.
But that's kind of an interesting, I think, turn on it. What they're arguing is that they can't possibly recognize that it's an ICWA case until after they filed the petition, right? So the protections would not be put in place until then.
Right. Well,
right.
I think what they're really saying, as I understand it, is that they're ignoring the removing, where it says a foster care placement shall mean any action removing an Indian child for temporary placement in a foster home. And instead they're saying we are not actually making the foster care placement until the child is ordered into placement, which happens at disposition, which is normally, 60 days after the initial hearing. And so they're saying we've initiated the foster care proceeding by filing the petition, but we don't actually get to the foster care placement until disposition, which is sometime later, and that's the place where we need to have the qualified expert witness and the active efforts. And so the problem is making ICWA work with the existing structure of California dependency law. That's the challenge.
Right. I see that. If I may, the one thing I would kind of point out is that California's, appellate divisions have been all over the place on ICWA. And I think you're probably going to have the same kind of situation here unless the Supreme Court will weigh in and say, how it's going to go. I think it's going to depend on how case law breaks down within the individual district courts.
Unless we can get some implementing legislation to clarify it.
Yes. I see their argument, but I think that that approach is. It's kind of playing pretty fast and loose with certainly with the language of the regulations and certainly the comments of the regulations.
And anticipation. And it seems like these emergency removal, regulations, these provisions were really addressing the situation that they had in South Dakota where children would be removed for extended periods of time without any ICWA compliance. And, there, in that case, it was removals for up to 60 days without the parents having a meaningful opportunity to be heard and without any compliance with active efforts or qualified expert witness requirements. So it seems very clear that that's what the regulations were intending to prevent. I'm having that argument.
Well, I think that because of the nature of California and the nature of how the courts have come down on ICWA issues, I think that unfortunately some courts are going to say, yes, you're right, and some courts are going to say, no, you're wrong. But I think I think clearly when you look at the comments to the regulations, the regulations are clearly meant to implement ICWA compliance as soon as practical, and before we have those court hearings, if at all possible. If the state has reason to know that a person is an Indian, that a child is an Indian child, then ICWA compliance should begin immediately.
So let me jump in here. First of all, it's super helpful, Steve. This is exactly the kind of meat and potatoes conversation this group was hoping to have. I see, Jill. I see what your point is now. I apologize. Jill was asking a question about emergency proceedings that I think I misunderstood. So, thanks. Gabriella is going to share with us the language of the Utah Supreme Court decision regarding the Chevron deference. So when she's going to shoot a copy of that over to Scott, and then he'll pull it up in the screen share. For some reason, I'm having problems with my screen share today. I don't know what Adobe's got going on. In the meantime, what other questions do folks have for Steve around the substance of the regulations and the law? We're in a pretty good spot having him available to us here. So what other questions do people have? You can ask over the phone, or you can ask in the chat. And Steve, I know you can't see, but there's a handful of people typing into the chat, so that will explain some of the silence.
I'm trying to download, but I just don't think my hotspot is sufficient to clue in here.
Yeah, that's okay. No problem. I have one question that's come up a number of times, and it's more of a practical question than it is about the substance, but I'm wondering if you could speak to it a little bit.
Sure.
What have been the most successful ways that you've seen in your work with ICWA identifying qualified expert witnesses, like to testify in ICWA proceedings? Are you seeing tribe-state partnerships where QEW lists are generated and passed around the courtroom, or how is that actually going down on the ground, and what are the most successful strategies you've seen for identifying QEW so that they can actually get in court and testify?
Well, Oklahoma has 39 tribes, and so we have, we pretty much run the gamut of you ask some tribes, who would you consider to be a qualified expert witness? Who within the tribe is an expert? And some tribes are going to say, well, we don't have any, or other tribes are going to have an immediate list. Part of our practice is that the courts are relatively, I'll say most of the district courts are relatively aware of the state, tribe, the coordinators, and we tend not to have a significant problem within Oklahoma as to who's a qualified expert witness, because the tribes will usually provide us with an expert. Even in the smaller tribes, they're usually pretty good about that. We have some tribes that are not. I think the best practice for that is to have the tribe at the very least talk to the tribal social workers for that. But I also like to address qualified expert witnesses within the context of the tribal courts, because a lot of times the judges for the tribal courts will know exactly who they've used as experts within tribal culture, and who they can kind of rely on. Some tribes, and certainly under the new regs, the tribes should have a list of people, and they should be able to immediately provide you with that information. I would imagine that that's going to be a very slow process for some tribes to produce that information.
Great, thanks. Super helpful. Yeah, okay. I could ask follow-ups, but I'm not. Jill's got a question here in the chat box. She says in Nebraska we have a state ICWA. We've been working on updating policy and procedures since the BIA regulations came out, and I've had the question about including placement with siblings as active efforts since it's not spelled out in the state law. Her opinion is that they should include anything listed in the regulations that isn't already spelled out in state law too. So I'm assuming that implicit in that statement is a question of what do you think about that? Do you think that that's a good strategy or the right strategy, Steve?
I do think that's a good strategy, and shout out to Nebraska. I actually practice in a tribal court that's right near the Nebraska border, the Kickapoos of Kansas. So, good job there in Nebraska. I do. I think that I think that would be the best practice.
Good. Okay, so now we have the quote from the Utah Supreme Court case regarding Chevron. So I'm wondering if it makes sense for me to just read it out loud to you, and that way other folks can also hear it if they haven't had a chance to gloss through it.
Sure.
It's a little bit long, like maybe, 7 or 8 sentences. So I'll just read through it, and then you can maybe give your own perspective on it.
You could email it to me, maybe.
Okay. Actually, that we can definitely do that. Scott, since you have it in your email, do you want to just forward it to Steve? And I will shoot you Steve's email right now. Give me 1 second here.
Sure.
Thanks. So just hang on 1 second, and I'll get that to you.
But if I just had to guess off the top of my head, I'll wait and see the quote.
Gotcha. Maybe it's coming in. Scott's sending it to you right now, but I'll just go ahead and read it, and then you can have a text in front of you. It says, under Chevron, the existence of ambiguity in a statute subject to implementation by a federal agency requires judicial deference to the agency's resolution of the ambiguity. Thus, if a federal statute is ambiguous on a question resolved by an implementing agency, the question for the court is whether the agency's answer is based on a permissible construction of the statute. This approach is not a viable one under Utah law. On pure questions of law, we have not adopted a Chevron-like standard of administrative deference. In fact, our case law has openly repudiated that approach, understandably. A key justification for Chevron deference to federal agencies is national uniformity, the avoidance of a patchwork of federal standards among the numerous federal circuit courts of appeals. That concern is not implicated in our state system, in which we have a single line of appellate courts and thus no real prospect for a split of judicial authority. So we have retained for the courts the de novo prerogative of interpreting the law, unencumbered by any standard of agency deference. The question for us is thus different from the one resolved by the cited federal cases, and we resolve that question differently, finding in our statute no room for the multi-employer worksite doctrine advanced by the Labor Commission, which obviously was an issue in the case.
Okay. Well, I don't, I want to kind of look at that, but just off the top of my head from reading that quote, that's kind of an apples and oranges thing. They're talking about how they're going to react to regulatory authority within the state. But ICWA isn't a state issue. This is a federal issue, and by the very nature of that quote, they have an obligation to apply federal regulations to a federal law. Unless I'm missing something there. Isn't that?
That's what I see as well, and it's refreshing to hear you say that, because this is the argument that the attorneys are holding so strongly to, that we just should not even follow it because the courts don't grant Chevron deference. But some of the distinctions that I thought could be drawn from these cases are, in those cases, the state administrative agencies had underlying statutes on that area of law, and we don't have a state ICWA law to defer to. And then uniform application is incredibly important for ICWA, where it wasn't in these other cases.
Yeah, I don't really see. I mean, I can see how they may be wanting to plug that in, but you know, they're talking about the Utah Labor Commission. They're not talking about the, you know, a federal agency, and ICWA is. I think I'll stay with. It's sort of an apples and oranges approach. But again, you know, you're probably going to have to end up in federal court to have a federal judge tell them, well, you've got to follow these regulations. Mm-hmm. But this is, they sort of recognize that the idea of the federal regulations. I think even the Utah Supreme Court might well find that you're required to follow the ICWA regs, because even they say, you know, the whole issue is national uniformity. That's not going to be that would be implicated in the state system if Utah went its own way and did not apply the federal regulations. So I think even by this quotation, you have authority to follow the regs. This is one of the problems I think that we see a lot with Indian Child Welfare Act cases. This is certainly what raised, what Kansas tried to do in Baby Boy L when they created the existing Indian family exception, which had the ludicrous approach of trying to determine if someone was Indian enough to be Indian, even if they were tribal members. A lot of times attorneys are too smart by half when they talk about ICWA, and they really want to try to parse things to the point to where they make no sense. Adoptive child versus baby girl was certainly that way. That's where you have Scalia rather acidly pointing out Alito's use of dictionary definitions to establish an approach at continued custody. It's the same sort of thing here. They're kind of comparing an apples and oranges approach to a Utah finding that I seriously doubt the Utah Supreme Court would actually implement nationally, and I have no doubt that a federal court would absolutely not recognize this. I mean, Chevron deference is just Chevron's one of those cases where there's probably not going to be a whole lot of modification in that, and even with a new Supreme Court judge, I think on a Chevron issue, there's no reason to believe that the Supreme Court is going to suddenly shift on a Chevron finding. So I don't really see it. I'm sure somebody perhaps a little more well versed in Utah law could explain it to me, and I might have a better understanding of it. But I'm not seeing the argument.
Well, I don't see it either. And my concern is that this is coming from an appellate attorney, that all of the attorneys who do the trial work are supposed to go to this particular attorney, and this is what she'll be advising them. And I'm concerned that it will have an impact on how the judges are applying the regulations. But what I had suggested to our general counsel in my memo that was sort of in response to the appellate attorney's memo about our quick reference guide was that whether or not our Supreme Court would grant Chevron deference is not something that should cause us to not apply ICWA, as the federal regulations are stating they should be applied. If they don't follow Chevron when applying Chevron deference on an ICWA case, and that's something that will have to be worked through the courts. But that's what I'm pushing with our general counsel, and hopefully that's what he'll come out.
Is Utah in the Ninth Circuit? 10th Circuit. Okay, so the only issue that I could see is and this is going to be kind of an interesting issue. The 10th Circuit has always kind of given states wide deference in ICWA cases. But regulatory authority, the 10th Circuit's just, I don't see the 10th Circuit overturning Chevron deference. That's just not been something that they've been willing to do. So I guess it could happen. The world is a little topsy-turvy right now, but I'm not seeing the Utah argument here as being effective, and I certainly don't see it from this particular language. I do not see the basis for ignoring federal regulations based on this. And like I said again, this is basic federal primacy. Utah Supreme Court doesn't get to determine what a federal regulation involving a federal law does. So I don't know. My position is that it's probably not well considered, and I would not think that it's going to be beneficial. But I can see this. ICWA was passed in 1978, and there are literally thousands of published appellate decisions on what amounts to a law that applies to less than 1% of the nation's population. So it's always contentious, and I can certainly see these regs being contentious. I just don't think that argument's. I think there are better ways to approach arguments against ICWA.
Yeah. Well, thank you. That makes me feel better in moving forward with our arguments. Implementing them.
I do think that that this is probably an issue that's just going to cause problems with Utah if they take this viewpoint. Because. One thing I always tell judges when I'm talking to groups of judges is that, even if you don't like ICWA, think about what it's going to do if you don't apply it. Because, 1914 says the response to not applying ICWA is a do-over. And that means the child is going to spend most of their life in a court system. They're not going to have that permanency that we all agree is really necessary for children. So, follow ICWA no matter how onerous you may feel it is, and get the child into a permanency. Get the child, concentrate on the child and what is best for the child. And that, of course, under ICWA is going to be probably, tribal placements, family placement preferences, things like that, regardless of what your opinion personally may be. That doesn't really, sway many judges, but I say it anyway. So.
I love that approach, just bringing it back to the child and what their experience is going to be. So that's something that I, if it's okay with you, would like to share with the judges as well, thinking about how it would affect the child in each case.
Well, absolutely. And the thing about what's the thing that we hate about these cases? It's the lack of permanency. It's how the child is just kind of being hung up. And, when you talk to the kids, when you talk to children who have been in foster care, That's the issue that comes up over and over and over again. They talk about how they never feel like they know their place. They never feel like, they're in a good place. And I mean, I've talked to children as young as 4 or 5 who are, very sophisticated in understanding that they are adrift. That's something that ICWA should be used. I mean, I think judges should really be the biggest proponents of ICWA because it accomplishes what a lot of times we can't do in state systems. It looks for the least restrictive settings. I think 1915 may give judges, pause to go beyond a little bit, at least, as to maybe a placement that we would look at and not accept. Maybe there's a placement that's not perfect within our standards, but ICWA may recognize that, and the state, the tribe may look at the placement preference, and they may look at it differently. I mean, I've had state social workers in Oklahoma say, well, there are just too many people in the house, and tribal standards may say, well, that's a cultural thing. Having other family members in the house is not. It doesn't mean that the house is inadequate. It means that the family is strong and together. So things like that, I think judges, if it was explained to them properly, I think they can really emphasize and really use in their practice.
Great.
Sorry, I tend to go on rants about ICWA sometimes. I do apologize for that.
You don't have to apologize. That's why you were invited here, so that we could listen to it, because it's insightful and adding depth to our understanding. Also, you're funny, which is always a good thing, especially when you have a call.
Well, if you don't laugh, you're going to cry in this stuff.
Yeah. So. Amen to that. I'm just going to do a quick logistics pause here for 1 second. If you're in the Adobe Connector, will you please type in the state or tribal CIP that you're affiliated with? I'm going to try to do a better job of tracking the states that we have attend, not because I'm trying to police who attends and who doesn't, but just for my own record, so I know, if we're hitting a number of jurisdictions, try to check both our breadth and our depth. So if you don't mind typing that in, I appreciate that. Thanks. All right, and while folks are doing that, if you could also, let me just say this. What other questions do you have for Steve around the substance of the regulations? We have 2 minutes more scheduled for this conversation. If we need a few more and Steve's willing to hang out, we'll take it. Otherwise, we can move on. So I'll set my timer for 2 minutes then, and we'll leave the space open for questions. And Steve, I know you can't see, but there's a couple of things coming in on the chat, so just hang tight.
Okay.
And I see a number of people have typed in their state or tribal affiliation, so thank you for that. If you haven't already, please do. God, I see, Gabriella, that you are responding. I asked Gabriella whether or not she felt like she had a local champion that would be willing to litigate the Chevron deference issue in Utah. She said that there might be some folks. So that'll be an interesting one to watch, see if some kind of federal litigation comes out of this constituency group. we might develop a bad rap for ourselves. So we have another question came in, Steve. I'll just read it directly, and then Jill, if you want to add any different inflection to it, feel free over the phone to do that. And we'll just sort of observe the conversation as you have it with Steve. She asks, what are your thoughts on the changes to timelines for withdrawing consent to TPR and adoption?
I'm sorry, say that again. You broke up just a little bit there.
Sure. What are your thoughts about the changes to timelines for withdrawing consent to TPR and adoption? And Jill, if you're on the phone here, maybe you want to say a little bit more about your question.
Yeah, so we're updating our policies and procedures, as I mentioned before. And one of the questions that the attorney I'm working with on this was how do we changing our format in our ICWA guide on relinquishment, because as we read it, the regulations now say that a parent may withdraw their relinquishment for any reason before a final termination decree or order. And that's different than it used to be, correct?
Okay, where are we talking here? Which provision? Are you talking about 114, improper removal, or what?
No, specifically about relinquishing parental rights and termination. I think we're getting a little hung up on whether it's a foster care or an adoption and, that sort of thing. I think that's creating some difficulties.
Okay. Let me see here. So are we talking about voluntary placements or involuntary placements, relinquishments? Are we talking about relinquishments in voluntary placements or relinquishments in involuntary placements?
Well, I would say involuntary placement.
Okay. And so we're into kind of that's always been kind of a particular issue within the protections of 1913. I don't think that I'm just looking here. Yeah. I'm just looking to see. Let me refresh my memory about. It's in section 23.128, the withdrawal of consent from a termination of parental rights, adoption. Yeah, I don't see the particular timelines changing in the regulations, and that kind of moors the pity on that, because it really does set up that weird dichotomy where if you receive a relinquishment under adoption, it's there may be an opportunity to withdraw consent for months even before the final decree is entered, but within a involuntary action, the judge is going to sign that order like they signed the relinquishment and the judge signs the order, and that's under ICWA. I think that remains probably the standard. It's kind of an odd thing, but I do think that there's no particular timeline change there.
Okay, so maybe we had it wrong before, because prior we had it stating in our guide, parent may withdraw relinquishment for any reason before the adoption decree, but
yeah,
that's for involuntary. I don't think for involuntary cases that's correct, right?
Well, I mean, they can withdraw their consent anytime before the termination of parental rights is the order of terminating parental rights is signed by the judge. But I mean, most of the times it's like, the attorneys are pretty much sprinting to the bench to get the judge to sign that order immediately, and I mean, that's one of those things that I think really comes from 1978 forward, that no one really back then considered, sort of a difference between a voluntary and an involuntary process. But I don't see that changing any really. I think it's still very kind of a very abrupt process if it's an involuntary action, and if it's a voluntary action, it just depends on how quick the attorneys are.
Okay, thanks.
Does that help?
Yeah, I think so.
Okay.
what about the withdrawing relinquishment of fraud or duress for up to 2 years? That to me, if you've got an involuntary case where they relinquished and you've got the final termination order or decree, that negates any ability to come back. But maybe I'm wrong.
Whenever I'm speaking to groups, I always remind them of the first cover of the old National Lampoon magazine. I don't know how old everybody is, but that kind of hits me in my wheelhouse. The first cover of National Lampoon had this really cute dog on it, kind of a spotted dog, kind of a mutt. And there was a huge handgun pointed directly at the dog's head. And it said, "Buy this magazine or we'll shoot the dog." And that was the first cover of National Lampoon. I use that as a definition of that's duress. Nobody wants to see that dog get its head blown off. That's an example of duress. Beyond that, just being told that your parental rights are going to be terminated, that's not so much duress as just a legal standard. Your parental rights may be terminated, depending on what the evidence shows, but and while that might certainly be a stressful situation, that's not the legal definition of duress. That's just a legal reality. On the other hand, I've had cases in involuntary actions where they've taken the mother. I had a case involving the Baptist Children's Home here in Oklahoma City, and they took the mother into a room. They set her on the far side of a desk, away from the door. They locked the door. They had a guy in a kind of a quasi-military uniform, kind of like a guard or something, stand in front of the door, and they spent the next hour telling her that she was a bad mother, that the children were much better off being adopted, that, it was just a really horrific thing. And at the end of that hour, she signed an agreement, which she almost immediately regretted doing. And we ended up, back in court, arguing that, in fact, this was a duress situation. Now, that happened almost immediately to it. But that's the definition, I think, of duress. Anything under that, anything where everybody kind of goes, yeah, you crossed a line there. I don't think under the new regs that's going to qualify as significant enough to change the 1913 standards in beyond the basic. You have until the order's signed, and then 2 years after that. Does that help?
Yeah.
Sometimes I don't really know. I've discovered if I don't have feedback from people nodding or looking puzzled, I have no idea if what I'm saying makes any sense whatsoever.
No, I got it. Thank you very much.
Okay.
Great, thanks. All right, so I'll tell you what, in terms of the questions that have been trickling in, it looks like they're not trickling in anymore, so I'm going to take that aside from the group that they've had the opportunity to ask the questions that were pressing. And also to thank you, Steve, for your time and contribution. We went a little bit over the allotted amount of time, but it seems like that was, what the group needed, so that's great. Steve, you're welcome to stay on the line if you want we have about 15 minutes left together. Otherwise, you're free to go. In terms of what we're actually going to do is not a ton of substantive stuff. What we'll do is we'll pop over to an open space forum and ask each other questions, and then we're going to schedule our next meeting and topic. So it's up to you if you want to stay on. You're more than welcome to. Otherwise, thank you very much.
I would I would love to stay on, but I am still sitting in a parking lot in Norman, and I've got it's time for me to head back to my office in Oklahoma City. So I will graciously step off, and I thank you for including me in this. And if you have any questions, I can always be reached at my email, which you guys have.
You got it. Thanks again, Steve. We really appreciate your time.
You're entirely welcome. Thank you for having me. Bye-bye.
Thanks. Bye-bye. All right, Dan. So hopefully that was useful to you, and you got your questions answered. So now what we'll do is sort of our normal scheduling work here. So the first thing I want you to do is I got to tighten up some of these dates for our next meetup, so give me 1 second to do that. And in the meantime, what I'd like you to do is take 3 minutes, I'll set the timer, and respond to the poll in the middle of your screen. It says, what ICWA-related project, program, or question are you wrestling with in your state that you'd like this group's help working on or troubleshooting? So I'll set the timer for 3 minutes, and I'll ask that you respond to that poll, and then we'll use that to kind of guide the work that we do in our March meetup. So setting the timer now, ready, set, go. All right, if you haven't already typed into the poll, please do so. And in the meantime, I have a second poll that I'd like you to respond to, which asks, what would you like to work on in the next meetup? If you don't have something that you want to bring to the table, what topic would you like to work on? So I've opened that poll up. You see you can just kind of scroll up and down on the poll itself and respond to it. So take a second, take 1 minute to respond to the poll. If you didn't type anything in that you'd like this group's work on or help with, if you'll select one of the options or one of the topics in the poll, that'll help guide the work that we do next week, or next month, sorry. And then once you've done that, I realize there's a lot going on, but this is a pretty tech-savvy group. I've opened up a new poll, and that one is sort of a get your calendars out and choose a date, vote for a date that you'd like to have our March meetup in. So you can respond to all 3 of the polls that are on your screen right now. I see in the short answer box, a couple of folks said that they'd like to discuss the difference between emergency proceeding and foster care proceeding. It's a good question. It's actually one that I think would have been great for Steve. I'm wondering if I put Steve's email in the chat box. If you could take him up on his offer and shoot him an email and ask him the question that you have about the difference between emergency proceedings and foster care proceedings. And maybe you can generate a conversation with him and bring that back to the group and tell us what you've learned. So I'm wondering, I don't know if I wrote those answers because I can't see it. All I can see is the response that you put up. But I'm wondering if you're willing, maybe in the chat, you could just tell me yes or no, if you're willing to email Steve your question and then bring that information back to the group. And while whoever wrote those is considering that, I'll point out that in the topic for next meetup, we have sort of by landslide here, curating one-page resource bench cards. So that's going to be definitely one of our topics next month. And then if we get some feedback on this emergency proceeding, foster care proceeding question, we'll also bring that to the table. So I'll give people another minute here or two to respond to the date for our next meetup. If you haven't, you can choose all that apply. All right. So I didn't hear back from the emergency proceeding, foster care proceeding folks. So again, if you want to pursue that question, what I'm asking or what I'm inviting is you to have a conversation with, thanks, Ann, to have a conversation with Steve and then bring that information back to this group so that we can sort of develop or build our own capacity and expertise around that issue. So that's great. Thanks, Ann. All right. So our next meeting is going to be on March 28th from 2 to 3:30 Eastern. And the topic will be curating one-page resources and bench cards. So here's the, normally what we do here is we say, you know, everyone select what you want to be, a consumer, creator, connector, or carrier. But if the topic that we want to nail down next week or the issue that we want to work on is curating resources, then what I would suggest is that everyone from this group over the next month, between now and the time that we meet, make it your goal to find one resource. To try to find one page or close to one page resource or bench card around ICWA and bring it to this meeting. And also email it to me, and I will put it in the files pod, and then we'll highlight a couple of them and talk about the strengths and weaknesses. We can do a focused conversation on them, and really kind of highlight the usefulness of the tools. So the ask is going to be that everyone bring one and send one to me. Then they should be the same one. I'm just going to type that into the chat. And I'll also send out a reminder for everyone. And typos are allowed in the chat, by the way. Sometimes I know to see that that's the case. So let me just say, does anyone have any strong objection to that idea? If you do, type it into the chat now. I'll give you 30 seconds or so to tell me whether I think that's a bad idea. Okay, great. So we have our next meeting. We have our next topic. Everybody has a little bit of homework that they'll do. They'll bring one source, and then we'll curate that information and share it between each other. I think what we'll probably end up with our open space here is, I'm not sure if we have any questions or not, but I want to honor the structure. And we were going to move into the lunchroom. I don't know if let's see. Veronica will probably know what this is. This is Skyline Chili. It's Ohio, Cincinnati style chili. Jen, you probably would love it since you're such a big fan of Cincinnati. I'm saying sarcastically. But we skipped the lunchroom today. Now we're open space. So who among you, or what questions do you have? So am I. What questions do you have for each other? So I'll set the timer for 1 minute, and you all can ask questions of each other. And if there aren't any that arise, then we will call it a day. So ready, set, go. All right, no questions, fair enough. So we'll call it a day. Thanks everybody for your attendance. Really appreciate it. Hopefully that was as valuable as it can be. For me, I feel like it was. Let me reopen this poll. Oops. Let me reopen these polls. On your way out the door, if you'll just respond to the two polls that are up in the room, I'd really appreciate it. The one on the top is sort of your standard, was this valuable question? And then the one on the bottom is, are you using what you've learned in this group on the ground in your jurisdiction? I'd just like to know whether or not the conversations and the resources that we're sharing and the information that we're sharing is being translated into any kind of project or practice. So once you've responded to those two polls, you're free to go. Thanks everyone for showing up and being so engaged, and we'll see you next month. Thanks.